SJC-13028, Cobble Hill Center, LLC, the Somerville Redevelopment Authority.
Good morning, Your Honors. May it please the court. My name is George McLaughlin, and I, along with Joel Fowler, represent the appellant in this case, Cobble Hill Center, LLC. As the court knows, and as the court has noted, the power of eminent domain is the government's most awesome civil power. In fact, this court in Devine versus the town of Nantucket, 449 Mass 499, stated, and I quote, "The taking of land from a private owner against his will for a public use under eminent domain is an exercise of one of the highest powers of government," period, close quote. The Devine court consequently went on to state and hold that eminent domain statutes are strictly interpreted to protect citizens from encroachment on their property rights. So,
Counsel, can I stop you? Why is this not a demonstration? Just cut to the chase. Why doesn't 46F apply here?
All right, well, Your Honor, first of all, I would say to the court, what is a demonstration? Somerville goes to great lengths to talk about 46F having all of these great powers, but a demonstration is not even defined in the definition section.
Right, and that often happens in statutes, and so we look at the plain and ordinary meaning. Why is this not a demonstration?
Well, I think if it is a demonstration, if demonstration, as we discussed, is not defined, I don't know what a demonstration is. But if you assume a demonstration is a kind of taking, then
well, no. Fine. Let's just assume it has its ordinary meaning, which is proof of concept.
Fine, Your Honor. Then what I would say is, they can, if we accept that, I don't accept that, but if arguendo, I accept your premise.
Well, I'm here to hear your argument. What is your argument as to what is a demonstration and why this does not fit?
Your Honor, I do not know what a demonstration is. I think it's not.
So how do we know, given your absence of knowledge as to what a demonstration is, that this is not one? I suggest you take a position.
Fine. My position is that the word demonstration is incomprehensible. It's not defined. There's no case law on it. I don't know what a demonstration is. But assuming they can make a demonstration, the problem I have with what Somerville has done is they haven't gone through the procedures, the legislative safeguards spelled out in section 47 and 48. Somerville's position has been, we have this great power in under 46F that is not defined, and we can take under section 11D, and we don't have to get approval from anyone. We can just decide we want to take this property, so they take my client's 4-acre, multi-million-dollar property, which they're then going to cut in half.
So, counsel, I guess I'm wondering, given section 46 has various provisions, some of which are tied to urban renewal plans and urban renewal projects, but section F is not. How do we square your position that sections 48 and 49 govern 46F when 46F makes no mention of urban renewal projects or plans?
Well, I think what you have to do, and Somerville ironically urges the court to do this, is you have to read all of these statutes together. You cannot read 46F and 11D in isolation. And when you read them together, Your Honor, you see that they're limited. For example, if you look at 46, it starts out by saying that an urban renewal agency shall have all the powers necessary or convenient to carry out and effectuate the purposes of the relevant provisions. I'll skip a little, granted in section 11. Then we go to section 11, and section 11 refers at the bottom in D to the provisions of chapter 79. Then when you go to chapter 79, section 1, it states, and section 79, as you know, is the eminent domain statute, it states, quote, the taking of real estate or any interest thereon by right of eminent domain may be affected in the following manner, period. A board of officers upon whom authority to take real estate by eminent domain on behalf of any body politic or corporate has been conferred by law, having first complied with all the, quote, preliminary requirements prescribed by the law, close quote. So I suggest and I urge the court to find that those preliminary requirements prescribed by law are the constitutional safeguards that this court talked about in the opinion of the justices regarding the stadium case. And those are the
problem with that case is that it specifically excludes, I mean, that was a case about whether or not you can take property to build a stadium, right? And in connection with analyzing whether or not you can take property to build a stadium, the justices in that case specifically compared it to something like that, what's at issue in this provision, which is eliminating blight and slums. And it said in that case, you know, when you're eliminating blight and slums, of course there's a public purpose and of course you can take land. For stadiums, we're not so sure.
I understand, Your Honor, but in the opinion of the justices, they specifically say the constitutional limitations requiring public property being taken by eminent domain to be used by private parties must be subject to legislative standards and principles. And the legislative standards and principles that they were talking about in that case are sections 47 and 48.
Mr. McLaughlin, you know that case is not the opinion of justices is not an urban renewal case, but let me suggest a different interpretation of the statutes. So 46F calls for the elimination of blight, and then you have chapter 112B, section 1, urban renewal project, again, prevent blight. And then you have section 11 that allows a taking to carry out any of the purposes of section 45, and section 45 includes blight as well. So why doesn't that statutory interpretation work?
I think it does, Your Honor, but I think when you look at section 45, you have to look at the last section of 45. In there, the legislature expressly limits the legislative finding of necessity to urban renewal projects. The language is clear. It says, quote, the necessity in the public interest for the provisions of this chapter relating to urban renewal projects is hereby declared as a matter of legislative determination. So what they're saying—
aren't you ignoring the first paragraph of section 45 when you jump to the bottom?
No.
The first paragraph of section 45 says the redevelopment of land in blighted open squares in accord with a comprehensive plan is necessary.
I understand that, Your Honor. It also says—
It doesn't say a comprehensive urban renewal plan, does it?
No, it does not. But again, when you look at 45, the last sentence clearly talks about urban renewal plans. And
absolutely, but you're ignoring the other two paragraphs.
Well, then, Your Honor, I would turn to section 47. And I think this is a very important section that ties all of these together. When you look at the first line of section 47, it says, quote, notwithstanding any provision of this chapter, an urban renewal agency may, with the consent of the department and municipal officers, and after a temporary loan contract for the purpose has been executed under the Federal Housing Act of 1949 as amended, take by eminent domain as provided in clause D of section 11. So, Your Honor, my position is this. Here is a specific reference to section 11D. Why is this authorization necessary if section 11D gives Somerville a blanket authority to take by eminent domain without complying with section 47 or 48? I think here, section 48, 47, and consequently 48 are unavoidably tied to 46 and 11D. So what it's basically saying, and it makes sense, is if you want to do a taking, if we assume you can do a demonstration project under 46F, and if you have the power of eminent domain granted under 11D, you have to comply with the procedures set up in section 47. And that makes sense, Your Honor, because if you think of the bigger picture here, what's going on? If we don't have a check and balance, which is what I cite the opinion of the justice's case for, we have a very important check and balance going on here. If you let local authorities just decide, we're going to take this property, we're not going to do anything, we're just going to decide it's a public purpose, blight, whatever the reason is, we're going to reach out and take it. And then if that's not bad enough without going through any check and balance, they give half of it to a private citizen.
What is, just so, you know, this is at a level of specificity that is difficult to follow, but what does 46F allow to happen then? 46F has to have some purpose. I know you want to read it all back into the urban renewal plan and sort of the standard procedures and the standard side. What does 46F allow the redevelopment authority to do, in your view, that's different from the rest of the statute? Because it's got to be in there for a reason.
I think, Your Honor, and I've thought long and hard about this, and I know you don't like my answer that it's incomprehensible and to an extent.
Well, but we're not allowed to say the legislature writes gibberish. We've got to find, they've got to be doing something here. So what is it that they're doing that's legal here?
I have strained, Your Honor, and I think assuming that let's read some meaning in here. And again, we're way beyond the plain meaning of the words. I think that what this may be getting at is minor situations, such as what the court dealt with in Marchese and what the court dealt with, the trial court dealt with in Tremont, and what the BRA talks about in its amicus brief. Very minor.
Okay, but I get that, Mr. McLaughlin, and you and Mr. Masterman have been fighting these issues for 500 years, so the rest of us have to catch up to you. But right. If that's the case, then you have a taking, you can use the taking power in this limited way. You're back to Justice Wendland's original question about what is allowed under a demonstration project. It sounds like your backup plan is, yeah, you can use the taking power as long as it's for this kind of narrow project that really is a classic demonstration project like Yawkey Way.
Right.
Is that your backup position?
With one,
I'm also troubled by Mr. Masterman's position, which is basically anything goes under 46F because we can trust these people to be good fiduciaries. That can't be right either. So I'm trying to figure out what an enforceable, substantive, limited 46F clause does. So it would help me if you give me what your view of that is.
My view is that it allows you to be nimble and make small takings to demonstrate a certain issue. Like in, I think the Marchese case is the perfect case. I think that go through a whole urban renewal plan and an urban renewal project to achieve the goal of simply taking an easement so that Fenway Park could use Yawkey Way.
Okay, so why is that? Why is, and again, I'm not saying you're wrong here, but I'm just trying, why is the Marchese Yawkey Way, why is that a demonstration project? Using this statute and this legislation and this, because there's a language at the end of this, right, where they throw in this sentence, could provide, the proposed development program includes a new municipal public safety complex integrated into a comprehensive reuse plan, which could provide a useful example for other communities throughout the Commonwealth, right? That's the only words of demonstration in this project, right? Why is that different from converting part of a pathway on a road? Why are they different under the statute? Why is one a demonstration project and the other not?
I think it goes to scope, Your Honor. But let me say this. I think that regardless of whether it's a demonstration or a full-blown project, as you say, you have to proceed under Section 47. That's the check and balance. So if, as the BRA and as Somerville argues, hey, we have to be nimble, and 46F allows us to be nimble. Yes, but 46F allows you to be nimble, but you still have to go to the Department of Housing and Community Development under Section 47, because what 47 says, and it's very important, and it relates back to 11D, 47 allows you to go to the Department of Housing and Community Development and get their approval before you go through the whole urban renewal project process. And so all Somerville had to do in this case is go to the Department of Housing and Community Development and get their approval under this.
And the particular words in 46F that cross-reference 47 are what? Because like I thought you were going to argue that the word plan in 46F must mean an urban renewal plan and that Justice Botsford was wrong in Tremont. But you're not making that argument. Well, you may be making that argument, but this one I've not heard before. Is there some language in 46F that cross-references 47 in a direct way?
Yes, Your Honor. And if I see that my time is coming up, and this will take a little bit of a minute, but I think it's very important because I think you're on to something here. 46F. 46F says at the beginning, it refers to Section 11, and it basically says, what 46F does is these are 8 powers that urban renewal agencies have, and then it refers back to Section 11, and there is no the word plan, Your Honor, is not used in 46F. And I think that's important for the court to note. But also, as I started to say, 46 refers back to 11. 11 says that you can do a taking under Chapter 79. Chapter 79, Section 1 says that you have to comply with preliminary requirements prescribed by law. And I think that takes us back to 47. And 47 specifically refers to Section 11D of the statute. So again, if Somerville has this awesome power they say they have, and all they have to do is do a demonstration under 46F, and then they can take under 11D, why did the legislature make the authorization of 47 necessary? They're all linked together.
Well, I think Mr. Masterman's going to come and say they didn't. And 47 has nothing to do with 46F, but I'll let him, I'm sure Justice Budd will decide when he gets to talk, but.
Well, I think this is a good time. Okay, Mr. Masterman.
Thank you, Madam Chief Justice. May it please the court, James Masterman with James Ponsetto for the appellee Somerville Redevelopment Authority. I had a brilliant oral argument here set, but I think what I want to start with.
Can I interrupt it then? Sorry. So just to cut to the chase, what are the limits to a demonstration?
I was going to say,
because I am troubled by the notion that Redevelopment Authority can do an end run around these very specific urban renewal plan and project requirements of 47 and 48, or 48 and 49, and not have to comply with those very public processes for getting approval for urban renewal plans and projects. Through a demonstration, which, as your brother noted, is not defined in the statute. So what are the limits to a demonstration?
Yes, thank you, Your Honor. And I was going to say, I'll try to answer Justice Wetland's questions together with Justice Kapner, and that is what the City of Somerville, the Somerville Redevelopment Authority, were confronted with in 2020 or 2019 was not widespread blight. There was blight, and it's admitted blight, but it was concentrated in a particular area, and they had options. As the courts have said since the Aladon case in 1939, when the local authorities that have specialized knowledge of their locale deem that some action is necessary, they opt for among the various powers that they have to fix that problem, to alleviate the blight, to eliminate it and to prevent its occurrence. They had the option at that point to decide, as they did back in 1968, when they had the large-scale inner belt urban renewal plan, whether to encompass an enormous area with all of the controls that come with urban renewal areas and the duration of an urban renewal plan that tends to go more than 20 years, as we've seen outside the courthouse with Government Center, the West End, or the South End. They had a different urban renewal problem. It was concentrated. It was not widespread. It was causing the same deleterious impacts on the surrounding area, an area that had been studied by the city of Somerville in Summervision and the Interbelt Master Plan. But the question in front of the SRA at that point, or the entire city, because the mayor and the city council were both involved, what do we do about this particular problem confined to this one area, to this one property, which is having similar impacts, negative impacts on the surrounding neighborhood? And the decision was, could it be demonstrated? Could it be demonstrated that if there were a surgical, targeted intervention by the public authority where private enterprise alone was not working, could that actually eliminate the blight and with a comprehensive redevelopment plan prevent its recurrence? And that is what the demonstration project is all about. The courts, again, since Aladon in 39 and Papadinis in 1954, from Berman at the US Supreme Court, all the way through Kelo in 2005, have indicated that when the local authorities deem there to be a blight problem, and that's the predicate of the public purpose, that there is blight or decadence or substandard housing, then the courts tend to defer to the local authority to determine what remedies will most effectively eliminate the blight.
So anytime, anywhere there's blight that's not within the urban renewal plan, a 46F project can occur, even if it's nothing special about it. Or is there some additional requirement? Because blight is, redevelopment authorities have no authority outside of blight, right? That's their big purpose. So is there something more to 46F than there needs to be a blight finding?
Not in terms of the validity of the public purpose, in terms of the taking. So long as there's a foundational predicate finding of blight, then the plan that is implemented by the Urban Redevelopment Authority to eliminate it and to prevent its recurrence is well-grounded. The question that Justice Kafka you pose is, where is the limit?
I'm confused, Mr. Messman. So I'm a poor person. I can't repair my house and it looks lousy. They can take my house with a demonstration project. There got to be more to a demonstration project than that. The place looks blighted, isn't there?
Certainly, yes, Your Honor. The Redevelopment Authority is not going to target a particular house. The question is whether that blighting influence has a deleterious impact on the surrounding neighborhood. Does a redevelopment of that area, is it consistent with a broader community-based planning plan like Summervision or any comprehensive plan? There is both parts of it. The predicate of the demonstration project and all of the actions of the Urban Renewal Authority must be a finding of blight. But blight isn't necessarily concentrated on one small house. It is a determination that the area itself, that this particular property in and of itself has some impact on the remaining area outside it. But in some ways, Your Honor, that finding of blight is the
Justice Kafker's question, isn't it important for us to know the definition of a demonstration? Because it seems to me that you could target a house that you consider not to be up to snuff to its neighbors. And that would be a targeted taking, but you would have to, in addition, show that the redevelopment of that parcel was a, quote, demonstration.
Yes, Your Honor. The
And what is, so I
underlying,
guess that's the other limit to this 46F power. And what does that mean?
that without a Section 47 urban renewal plan in place, that without a broader stroke urban renewal area, that the same type of remedial impact, or remedial effects of an urban renewal authority can in fact be used for a targeted intervention to demonstrate whether that would work, or must it be this much larger, long duration, multi-property?
To demonstrate what? I think that's, Justice Wendland and I are asking the same question. To demonstrate that blight will be eliminated? Of course that's gonna happen because you're gonna put something nicer in or just knock it down. Don't you have to demonstrate something innovative? I mean, to me, a demonstration project is a pilot program that teaches us how to do something that we've not done before, or that's novel, so that we have to make a special exception and give a lot of power. It's a big deal, but it can't just be because there's blight out there, because then why have urban renewal plans? We can just do this with a demonstration project.
If every property within an urban renewal area is blighted or decadent or substandard, then I think Your Honor is correct, Justice Kapker. You could have a huge demonstration project. The onus on the government in this situation is greater because it must demonstrate that every property within a demonstration project is blighted. And then there is this notion that the demonstration has to be achieved by the taking and the elimination. No, it does not. There has to be a plan in place that demonstrates that if this property were to be taken and in its stead comes something that the Urban Renewal Authority believes to be better for the community, fully more integrated, has the ameliorative impacts that are desired, that you don't have to have a 50-acre urban renewal plan with all of its controls over the next 40 years. That's what the city of Boston
But again, so just I mean, because I don't want to weave this, because this is a big deal and we haven't answered this question. But again, what I get out of what you just said is that there needs to be blight, and we need to have something better come out of it for the community. Is that your standard for a demonstration project? Outside of, there needs to be blight in the entire area that's 46F is applying to, and that it needs to produce something better for the community. Is that all that's required to be a demonstration project? Because that's a pretty powerful taking power for unelected officials to have, and none of those political controls that come into play on urban renewal plans, right?
There's a lot there in that question you're on to unpack. Number one, yes, I think that's the heart of urban renewal. The heart of urban renewal is to identify substandard housing, decadence, and blighted open areas, and where by private enterprise alone, it was not being alleviated, and to come in there with an extraordinary power. We understand that, as Mr. McLaughlin indicated, the awesome power of eminent domain, but the eminent domain power has always been a means to achieve the public purpose, and that is the elimination of blight and the implementation of a plan. And
so let me try this again. Urban renewal projects and plans are designed to eliminate blight, correct?
Yes, in part.
Okay. Now you're saying that demonstrations are also designed to eliminate blight, right?
Yes.
Okay, so what is the difference? Doesn't it have to come from how we define a demonstration? Because otherwise, I could take an urban renewal plan and just divide it up into smaller parcels, however you measure that, and say each one is going to be taken. without all the process that I need, all the bother of the public hearings and the approval of everybody else. I'm just going to take my urban renewal plan and I'm going to divide it up into 4-acre parcels. And each one I'm going to take as a quote unquote demonstration because it's going to eliminate blight.
I don't think so, Your Honor. If each of those 4-acre parcels,
I'm just asking you.
I don't think the Urban Renewal Authority can go around and decide that every 4 acres is blighted unless there is the foundational concept of blight. You could have. We've experienced it in the Commonwealth and across the nation where acres and acres and acres of degradation could in fact support that kind of approach. But in the demonstration project, it is targeted. It is targeted not geographically necessarily, but where the blight is found. And once that blight is found.
I think you're putting a lot in targeted. To me, prevention and elimination of slums and urban blight, that's what the demonstration is going to be able to carry out. Something that is unique, is just as Kafka said, it's a pilot project. Look at what we're doing over here, Arlington. See how this worked? Or Cambridge, see how this worked? We were able to do this in this way. And you can take this demonstration and deal with your blight in this unique way. And that way, because this is so unique and it's going to help as a matter of how to address blight, that we're going to let you avoid all the procedure that you need to avoid otherwise for most urban renewal projects. Doesn't that what demonstration, common sense, colloquially mean?
I think that's right, Justice Lowy. I think the fact here is that the city of Somerville has in fact said, we're not going to adopt a broad, comprehensive urban renewal plan, which we had once before in this area. That's not what is necessary here. That particular area is blighted. And yes, Arlington, Springfield, Chicopee, take a look at this idea. We are going to focus on the blight that might have this deleterious impact on this neighborhood. And we're going to say, this is how we're going to do it. We're going to acquire this land. Here's the plan. It was fully vetted publicly. It was approved by the city council. It was approved by the mayor. And we are not going to keep our land use controls there for the next 30 years. We are going to get in, eliminate the blight, allow us to implement this public safety building. If there is a private party to achieve this public purpose that will assist us in eliminating the blight and preventing its occurrence, we'll do as urban renewal authorities have done from the very beginning. And we will contract with them and do so. And then we're done. That project is over. There's no further controls in place and they go about their business.
So it sounds like you're saying the urban renewal plans allow us to take a giant area, only parts of which are blighted. And we go by all the procedures in the urban renewal plan. But we can also just ignore this for everywhere else in Somerville and say, and we have the ability under 46F, if a particular area is blighted, we can take it and clean it up. Doesn't matter what we do there as long as we make it better. Am I summarizing your argument correctly or am I misinterpreting?
I think that's right, Your Honor. I think there's the public official in the local, in the city, as you indicated, in its fiduciary capacity, can look at the problems of what that particular city is encountering and address it in a number of ways. One of the ways to address it is to adopt a demonstration project that in this one, as the court has seen in the appendix, is thorough. It is well drafted and it is basically looking like an urban renewal plan would otherwise look like, and it addresses this one particular area.
Okay, if we disagree, Mr. Masterman, that there's an additional requirement of a demonstration project, not just that it's blight and it produces an improvement, but that it also has to be something more novel or innovative. There's some substantive aspect to demonstration project. Can you still win under 12C here if we believe that that the power is not quite as broad as you do, that we think demonstration has a meaning of innovation and example of some sort, do you still win under 12C?
If it requires some innovative approach, I would believe that in this particular case, it has satisfied it.
And how has it satisfied it here? What is innovative here besides that again, we think there's an additional requirement, and I'm not saying we do, I'm just posing this, that we think that something beyond blight and you're going to make the blight go away is a 46F has something else to add to it.
Yes, Your Honor, it is demonstrated to every other city and town in the Commonwealth that in fact you can target this particular property, and use the tools of the Urban Renewal Statute to implement a plan for to prevent the recurrence of blight. That is not something, as the cases have said all along, the courts have allowed the adaptation that the cities can adapt to the problems that they recur. We're not dealing with widespread blight in our cities, thankfully. We're dealing with pockets of blight that must be remediated. And in this situation, what is being demonstrated in a use of the power that has been embedded in the statute from its beginning is that you can use it in this more surgical, targeted, constrained area. That's the demonstration.
Isn't that, it sounds like something like spot zoning or something. Is that what you're describing, that the the redevelopment authorities can go in and sort of, just do this kind of, I don't know, but your point is that the demonstration is we can demonstrate solutions to targeted blight. That's what you view demonstration means, that we demonstrate how to fix a isolated blighted spot.
That's correct. And it would be the courts would say that the public official may be the best party to know which among the various powers within 121B to use. That at this time, when we don't have these broad, large, widespread areas of blight that we've encountered for 80 years in the Commonwealth, we don't have that at this point. Yet, blight continues to be a persistently vexing problem.
So, Counsel, can I stop you for a second? So you're not relying in any way on the plan itself, that there was going to be this public safety complex with these other parts of the parcel to be used, the 4 phases. You're not relying on the actual plan itself. You're saying the demonstration is that we can take this mini parcel and fix it.
And beyond that, Your Honor, we simply cannot just eliminate the blight. We've got to demonstrate in the demonstration plan that the redevelopment of it that had not occurred by private enterprise alone would in fact prevent the recurrence of blight. So yes, the redevelopment plan is an important component of this. We just can't, otherwise you can just take the land and leave it fallow. That's not what's required here. What's required is a true plan of redevelopment and demonstrating that in fact, if one does it in this targeted way, and you put a public safety building or you bring in a private party, that would not only eliminate the blight with the taking, but in fact would prevent its recurrence on a going forward basis.
Is there any legislative history on 46F? Is there anything we can turn to for guidance that explained what demonstration meant to them? Is there anything you've seen on this that we could, and I would request Chief Justice Budd, if there is anything that they're aware of, that they submit a 16L letter, because that was really not the focus of the briefs as much.
That sounds good. If you guys have anything, you can submit it by way of a 16L letter. And I thank you for your arguments, and we're going to move on to the next case.
Thank you, Your Honor.